You are watching the LemonAid Podcast with Amar Law Group. Join us as we unlock the secrets and expert tips you need to know now.
Hello and welcome to the LemonAid Podcast with Lemon Law expert Shalev Amar. I am your host, Kevin Rosenquist, and today we're peeling back the layers of an important topic for anyone navigating the lemon law world: how mediation and litigation stack up when it comes to resolving those frustrating lemon vehicle disputes. Shalev, welcome back.
Thank you, Kevin. Thanks for having me.
Let's start by talking about the alternative dispute resolution, or ADR. Can you explain exactly what that is and how it can work in lemon law cases?
Sure. Well, there's two main forms of alternative dispute resolution. One is arbitration, and the second is mediation. So here's the difference between arbitration and mediation. Arbitration is basically like a mini trial, and you have an arbitrator who is basically in the position of the judge and jury. And the arbitrator will make rulings, and then at the end of the presentation of the case, will make a decision in favor of one side or the other. So that's the way arbitration works. It's the benefit to arbitration is it's a lot quicker and cheaper typically than formal litigation. The downside to arbitration in the lemon law context is that oftentimes arbitration programs are administered by basically programs that are fully funded by vehicle manufacturers. So yeah, imagine going to court and the judge is paid for by the other side. Are you going to feel very comfortable?
Yeah, that seems like a conflict of interest.
Yeah, so it's basically, I feel like it's going into the lion's den. Now, if it's an arbitration administered by the state or by a court, that's a little bit better because it's not funded by the manufacturer. But then you would have to look at the individual arbitrator appointed and see, okay, because typically when an arbitrator is appointed, that tends to be a practicing attorney. So you need to look at his or her practice area. Like, are they on the plaintiff side or on the defense side in the civil context? Because, for example, if you get an arbitrator who is in products liability defense or insurance defense, they tend to not be very consumer friendly. Whereas if you get an arbitrator who's in personal injury or handles consumer fraud matters, then they're more likely to be consumer friendly. Although obviously there could be exceptions. And so that's arbitration. The main thing about arbitration is, like I said, it's like a mini trial and the arbitrator makes a decision in favor of one side or the other. Mediation, on the other hand, is also informal. It's also way quicker. Like typically an arbitration will be, a couple hours, no more than half a day. And mediation is the same. It's typically 2 to 4 hours. The difference in mediation is that you have a mediator, which is a third party neutral. It could be an attorney or it could be a former judge. And the mediator's purpose is to persuade both sides to come to an agreement. The mediator cannot force an agreement, but the mediator can obviously give arguments to both sides, let them know the negatives in their cases, the risks involved. And the purpose of mediation is to bring both sides together to compromise, to reach a mutually agreed upon settlement. So in arbitration, the arbitrator decides. In mediation, the parties, the consumer and the company, they decide, but with the help and support and persuasion of the mediator.
Is there, what are the advantages, I guess, to going with the ADR model compared to traditional litigation? It's when it comes to resolving lemon law disputes.
I would say the biggest advantage is, well, there's several: time and money.
Yeah.
To litigate in court is very, very expensive. It's just the nature of the beast. There's legal work that has to be done with the court. For example, scheduling stuff, case management stuff, hearings with the judge. And as the case proceeds, discovery, questions, written questions to each side, research, depositions, which are questioning of witnesses in front of a court reporter under oath, legal hearings, legal motions. There could be motions to prevent witnesses from testifying, motions to exclude experts, motions to dismiss a case, motions to dismiss part of a case, motions to restrict the evidence that can be presented, and then the trial itself. which can be very time consuming and also stressful. And so if you have a method that can help you avoid all of that, that's obviously something that can be beneficial as long as it's a fair process. Like I told you before, I have concerns about arbitration that is paid for 100% by a manufacturer, because I just don't feel that it's a fair process. In fact,
how can it be, right? How can it be?
Yeah, in fact, just follow the money. And they've even done studies. Social scientists have done studies about money. It does have an influence. People know where their bread is buttered, and it can influence the decisions that people make. On top of that, I've seen an audit of some of these programs, and the way they even train the arbitrators is to accept defenses that would not be acceptable in court. Like what's one example of that? Well, if the dealership took too long to do a repair because of a delay in receiving a part, because there might have been some kind of supply chain issue, well, that's a legitimate defense. No, it's not. Under most laws, it is not a legitimate defense, but that's their training. So that's just one little example, because that's putting the burden of the part not being available on the consumer instead of the manufacturer. And LemonLaw is designed to protect consumers, not manufacturers. So that's completely inappropriate. So that's one example. But look, if it is a fair process, and especially mediation, just because mediation does not have that third party like an arbitrator ruling one way or the other. Again, the mediator is trying to persuade both sides to come to an agreement. So a mediator's purpose is not to say, hey, you win or you win. The mediator's purpose is to persuade both sides to come to an agreement that they can both live. Because one of the benefits of mediation as well is if both sides agree, both sides are more likely to comply with the terms. Versus when a ruling or a judgment is handed down and one or the other side is very unhappy about it, you might have less compliance in those situations.
Are there disadvantages to mediation?
In a mediation context, I really can't think of any disadvantage to mediation unless one side or the other has zero desire to compromise and zero desire to have any kind of resolution. They 100% want to fight. That's very rare, by the way. But in those rare circumstances, then I think mediation is just a waste of time.
Can you kind of describe the typical mediation process in a LemonLaw dispute? Like what does that look like from start to finish?
Definitely. So typically what happens is, not always, but typically the parties will start together, both sides, in a conference room with the mediator. The mediator will explain the process. He'll ask both sides if they want to give a short statement before he separates the sides. Then what happens is the sides go to separate rooms. Either one will stay in the conference room and one will go to an office space, or they'll both go to different offices. And then the mediator will spend time with each side, hearing their arguments, exploring the facts, exploring the legal claims and defenses, and will basically be taking offers and counteroffers or offers and demands back and forth. And while the mediator is doing that, the mediator will basically be beating up on both sides, not personally, but just beating up on their cases. Because if the mediator goes to each side and is like, oh, you have the best case ever, you have zero chance of losing, you shouldn't compromise, like obviously the case is not going to settle.
Right.
So it's the mediator is not doing his or her job if they're not, letting potential pitfalls, potential problems with the case. And the mediator, a good mediator, will do that to both sides. And basically also convey the other side's position, but typically will do it with kid gloves. Like, when the parties, especially if they're disagreeing, they might not be happy with each other. They might say things in harsh ways. The mediator will tend to make the argument of the other side, but not in an attacking, nasty kind of manner. So yeah, mediations tend to be very productive. Over all the years that I've practiced law, a large percentage of the cases that I've had go to mediation did in fact settle, like a really large percentage. I'd say probably about 90%. If I had to come up with a figure, give or take a couple of percentage points.
What's the difference in potential outcomes between mediation and a court trial?
At trial, it's typically all or none.
Right.
So either one side wins and one side loses, unless you have a hung jury, which is extremely rare. In over 20 years of practice, I've never had a hung jury in a case that went to trial. But apart from that, and what happens with a hung jury is then you have to have another trial because the jury couldn't agree on the outcome. And so trial is basically winner take all. Although, look, if you're bringing multiple claims, sometimes the jury will split the baby. Will say you prevail on this claim, but you don't prevail on that claim. In a lemon law context, it could be you prevail on the federal lemon law, but you don't prevail on the state lemon law, for example. So that's the way a jury could split the baby. Also, if it's solely a federal lemon law case, then the jury decides on the amount of compensation. And obviously, the consumer will be arguing for higher compensation than the manufacturer will be. And what a jury can also do is if they award a buyback, unless there's a formula set by statute, in some states, like in Arizona, it's up to the jury to decide what is a reasonable offset for use, which is typically cents per mile. So sometimes the jury, what they'll do is they'll rule in favor of the consumer, but they'll give a pretty high mileage offset. Not always, sometimes it'll be lower. But again, in trial, it's basically win or lose unless there's a hung jury. And so one side will tend to be very happy and the other side will tend to be very unhappy. Mediation is different because a good mediation will basically be win-win. Like both sides get some of what they want. And both sides also limit their risk and their expense of going all the way to trial. So they limit their risk of completely losing. They also lessen their expense because they're not going to have to spend a bunch of money fighting. They also dramatically lessen their stress because you don't have to go through the stress of being a trial.
Right.
There's a judge who is an appellate judge, famous judge named Learned Hand. I don't know how you could be anything but a judge.
I was going to say that is like the greatest judge name ever.
Yeah, if your name is Learned Hand. I don't want to murder this quote, but it's something to the effect of that there's only two things worse than being in trial when it's your trial: severe sickness or death. It's extremely stressful. The other side's bashing you. You know, you have a jury of strangers who you don't know, who have your fate in their hands. You don't know the judge either, typically. And so it's just a stressful situation.
Sure.
And, you know, you have to sit there while the other side says things you disagree with, or might even say things that you consider to be false. The other side might personally attack you, say, you know, you're a finicky person, you have buyer's remorse, you're overblowing things. You know, a typical defense, just so you know, of a manufacturer is to blame the victim. That's a typical defense. And the second part of their defense is the spaghetti defense. You throw a bunch of spaghetti on the wall and see what sticks.
Yep.
So they'll argue all kinds of ridiculous nonsense, hoping that the jury will buy one of their ridiculous theories. It's an unpleasant, stressful situation. I've even had clients who won trial who got what they wanted, but still were like, if I knew it was going to be this stressful, I wouldn't have gone through this. So mediation helps you avoid all of that. Helps you minimize your financial risk and minimize your stress. And even if you don't get 100% of what you want, it's something that you can live with and that helps you. And then you get to avoid all of that trial stuff.
How do you prepare your clients for mediation?
Well, for mediation, we go over the facts of the case. We discuss what the client wants out of settlement, ideally, and then what is the client's absolute minimum that they're not willing to go below. And we also just educate them about the process, just basically what I told you about how a mediation goes.
One more question I'm just curious about as far as trial goes. Like conventional wisdom would say that a jury is going to sympathize more with a consumer than they will with a giant car company. Is there more risk for the manufacturers than there are for the consumer if it goes all the way to trial?
I think on average there is more risk for the manufacturer because of that. Most people are consumers. Most people have had to deal with defective products.
Right.
So that obviously benefits the consumer. On the other hand, it's not 100%. There are definitely exceptions. Sometimes juries, they don't understand the law. Sometimes they are basically tricked into believing illegitimate arguments or tricked to focus on trivial issues that don't really matter to the case. And there's also a bias against lawsuits.
That's interesting.
Because there is, as we all know, the McDonald's case and this, that, and the other of these huge verdicts, and people think that too many people are suing for trivial reasons, and that, they're also taking time out of their lives to be there. And so, there's biases that go both ways.
Sure.
I'd still say overall the bias is more towards the consumer, but it's not as much as you would think. Because again, people don't like lawsuits. They're upset that they're missing time out of their lives.
They have to be there.
Yeah, from work, school, family obligations, even vacation. So yeah, they're not happy to be there. Unless they're, retired, have nothing better to do and just, see it as interesting. But that's rare.
Get them out of the house.
People are trying to get out of jury duty. They want to live their life.
Right.
And
Right.
so yeah, I'd say overall it's more favorable to the consumer, but I would say it's probably 60-40. It's not, some people would think it might be 90-10. No, it's not that. It's slightly in favor of the consumer, but it's also case by case. Sometimes you might end up with a jury pool who also ideologically are just more business oriented.
Sure.
And they know that sometimes customers can be unreasonable or can complain about frivolous issues. And so, there's that bias as well. So like I said, I think it's basically 60-40 in favor of the consumer. But that's just overall. You could end up with a jury pool based on the factors that I've described. It could be 60-40 in favor of the manufacturer. And sometimes also, if you get engineering types or engineer types or medical professionals, they could have very exacting standards for what they believe should prove a case, which is actually not required to prove a case, but that's just their internal standards.
Yeah, that's how they are. Yeah.
Or there's even, like, they expect you to be able to describe the source of a defect, which actually a consumer does not have to describe the source of a defect. The fact that it's being repaired under warranty is an admission of defect. But the engineer might want to know the very specific component that's defective, which is a very difficult standard and not the standard that's required, by the way, in a LemonLaw.
Right.
And there's also people who've seen like CSI and the CSI spinoffs, like expect this huge smoking gun type piece of evidence, which again, it's not really like that. Oftentimes you're just looking at documents, repair records. So yeah, that could be a challenge as well.
That's interesting. Well, thanks for joining us on the LemonAid podcast with LemonLaw expert Shalev Amar. Please like and subscribe to our channel and leave us a review. Shalev, give us those websites. How can people get in touch with you?
Sure thing, Kevin. So we're in multiple states. If you're in Washington State, our website is WashingtonLemonLawAdvocates.com. In Oregon, OregonLemonLawAdvocates.com. In California, it's CaliforniaLemonLawAdvocate.com. And in Utah, it's UtahLemonLawAdvocates.com. In Arizona, it's ArizonaLemonLawAdvocates.com. In Colorado, it's ColoradoLemonLawAdvocates.com. And in Nebraska, it's NebraskaLemonLawAdvocates.com. And then a slightly different URL in Nevada, it is NevadaLemonLaw.info. So yeah, if you're having a lemon vehicle situation, please check us out. By the time that this airs, we may be also in New Mexico. So if you're watching this or listening to this in New Mexico, that would be NewMexicoLemonLawAdvocates.com.
Awesome. Well, thanks, Shalev. Thanks so much for all the info and great to have you here.
Yeah, thanks again, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and comment below.